with more strategies so as to strike at the humanity. Media must promote morality and public conscience, good conscience. This is what we have been discussing here. Media should not go to promote immorality and should not work in the field where the human living is put to a danger, both morally as well as in the matters of safety is concerned. Media should not stall the justice. That's what the speaker from the United States have been telling, that the media reports tend to create a parallel judicial thoughts. Media has a role to promote justice also, because we consider media as fourth estate of our democracy, or any democracy for that matter. This is the fourth estate, this is the fourth pillar. So with these words, I think this House has successfully discussed the scope of Press Council of India as particularly applied to the Indian context, and the peaceless state of Press Council of India, and the need for creating a special forum or consolidating the laws so as to take into its fold the qualifications expected of a journalist, the role and the responsibilities of a journalist, and the public safety, national integrity, good conscience in the society. And I hope that these discussions have emerged into a very useful thought force to the country to guide the world when the entire world is suffering from the menace of terrorism. Thank you.
Summing up so many things in such a short span, now gentlemen, we close this session. We will reassemble in a short while. The next session will be commercial arbitration and mediation. So thank you very much everybody.
Thanks for showing up first of all at 5 o'clock in the evening. Difficult to have people stay back. Congratulations to the organizers here. Started about 10 o'clock and so 10 o'clock to get informed. Yeah. I have been invited to speak on the topic, the jurisdiction of the Indian court to interfere, assist, interject, whatever you call it, in international commercial arbitration. The time allotted is 6 minutes, 8 seconds, 6 to 8 minutes, with a flexibility at the maximum extension of 10 minutes. And I shall try to address it and keep things the minimum as possible. To begin with, international commercial arbitration, we all know, are arbitration between non-country entities. And that's as I want to elaborate. Next question is, if they come from different jurisdictions, different countries, which courts will have jurisdiction? There have been several thoughts, there have been several measures taken. Different laws and different jurisdictions provide different answers to it. 85, a model law was drafted by the UNCITRAL, which was the United Nations Commission on International Trade Law, and which gave some some direction to what the jurisdictional answers would be like. I'm here to present the Indian perspective on it. India in the year 1996 adopted, with the least amount of application of brain, if I may say so, the UNCITRAL model law. So very few modifications made, little adoption, little adaptation. Predominantly the two schools of thought on how can we tie arbitration proceedings, so far as the judicial decision is concerned, to any given legal system. On the one end of the spectrum is the localization model, which essentially means that all the arbitral proceedings must be institutionalized and tied up to a particular legal system, which legal system is determined on the basis of where the arbitral proceedings take place, which is in English for instance called as the seat of arbitration. On the other extreme is the multi-localization model or the delocalization, truly translational model of international arbitration, which is that if international arbitration, really speaking, is a code in itself. It is something sui generis, which is something which is floating in the air and is not tied to any legal system. To the best of my understanding, the 1985 model law and its incorporation in the 96 Indian Act is inclined heavily towards the localization model and tying everything therefore to the seat of arbitration. In 2002, arose for the first time for the Supreme Court of India a question of granting measures of interim protection to an international arbitration which was taking place outside India. The seat of arbitration was outside India. So here's the dichotomy. The legislation, the model law are heavily inclined towards the localization model, which is fixed and tied to the seat of arbitration. The case was the Bhatia International case versus the bulk trading. 2002, a three-judge bench of the Supreme Court pronounced a decision holding essentially that the Indian courts have jurisdiction over international commercial arbitration taking place anywhere in the world unless the parties had expressly excluded the application of the Indian law. I wouldn't delve into the reasoning of it. For most part of it, I think it is counterintuitive, and I think that's not neither the forum nor the time permitted to go into the question of how well structured, well drafted the reasoning was. However, the principal conclusion that the court arrived at was irrespective of the seat of arbitration, the Indian courts will have jurisdiction. The background in which the case arose was the foreign party in this case was looking for some sort of protection with respect to the assets of the Indian party that was situated in India. The Indian party, I mean, as anyone would guess, was Bhatia International. The foreign party was bulk trading. The seat of arbitration was Paris. The agreement, the arbitral clause specifically said that this is to be administered and institutionalized, administered by the institution of the International Chambers of Commerce in Paris. In fact, there was discord amongst the parties to the appointment of the arbitrator. The ICC went as far as appointing the arbitrator. Professor Hannon from the UK was appointed as an arbitrator. There were some apprehensions in the mind of bulk trading that Bhatia International might, for reasons best known to it, displace its assets, either which would essentially mean either sell them off entirely or put them in other jurisdiction and take them out of India. And since this was a case of providing some sort of interim protection, the court inclined. I think the desirability of the ultimate conclusion is something that only a few of us would disagree with. the manner, however, in which the judgment was written and the ultimate conclusions that followed from the decision were perhaps not as well considered. Knowing the ingenuity of lawyers, most of us here are lawyers. You give them a seed, in a day they can produce fruits out of it. They can have the whole plant and they can have the fruits there. The Bharti International decision was taken to an illogical end and was contended before the Supreme Court in the year 2008 in Venture Broking versus Saptam Computers case, that the power to set aside an arbitral award, which was a power conferred by the 1996 Act, was available also in respect of a foreign arbitral award. An arbitral award which was rendered outside India, and the basis of arguing that was because the Indian Act. Essentially, when I say the Indian Act, I mean Part 1 of the Indian Act, which I don't need to confuse people with right now, but you could perhaps take it as the Indian Act applies irrespective of the seat of arbitration. Motivated by the consideration that in case the Venture Global Award is allowed to be sustained, certain mandatory provisions of the Foreign Exchange Management Act of 1999, which is the Indian legislation, a mandatory Indian legislation, would be violated. The Supreme Court decided to set it aside. There is a conceptual difference between setting aside an arbitration and not recognizing it, or rather a step further, of refusing to enforce it. The Indian Supreme Court, however, decided to set aside or vacate, as it is called in the American physiology, the arbitral award, which was passed in London by QC. So essentially, that's where we are in 2010. April to 2010, certain amendments have been proposed, and the discussion paper is out. The discussion paper proposes to amend Section 2.2, that's Section 2, subsection 2 of the Arbitration Act, which said that the Arbitration Act shall apply only where the seat of arbitration is India. There's also a proviso added. However, interim measures of protection will be available in case the seat of arbitration is in a convention country. And what I mean by when I say convention country is a country which is a party to either the New York Convention or the Geneva Convention arbitral awards. There are some serious lacuna. I don't know whether time permits. So how much time is there? I was allotted 6 minutes. Another 1 minute. Okay, so in that case, I don't think I'm left with time to discuss the merits of the amendment. My suggestions or my reservations, so to say, on the amendment, the proposed amendments are now with the Ministry of Law. They've already been documented in the Senate. And in case any of you would be interested, I would be glad to share it with you in case you would leave a business card of yours with me. Thank you very much.
Thank you, Mr. Sachdeva. Now I request Mr. Ratan Singh, who is here, to kindly express his views. But I request all the speakers kindly to be in brief, so that this session is cut short because of last session. So we have to finish in any case by 5:45. Kindly take care.
My friends on right, friends on the hall. In fact, impression given to me was that I think the session will be tomorrow.